A newspaper ran an advertisement with a few small factual errors. For that, an Alabama court ordered it to pay $500,000. And that was just the first of many such suits, enough together to bankrupt the paper and drive it out of an entire region of the country. The year was 1960, and the ads supported the civil rights movement. The lawsuit was never really about the errors. It was about silencing the press. And the Supreme Court's answer rewrote the rules of free speech in America, protecting, whether you realize it or not, almost anyone who criticizes the powerful today, including a channel like this one. This is the story of New York Times versus Sullivan, the case that decided the government cannot use libel lawsuits to punish criticism of public officials and gave American free speech room to breathe. One note before we begin: this is legal history and education, not legal advice. Start with the area of law at the heart of it. Libel, a form of defamation. The idea is old and reasonable. If someone spreads damaging lies about you, you can sue them to protect your reputation. But now turn that power in a different direction. What happens when a government official uses a libel suit not to defend his good name, but to punish people for criticizing how he does his job? That is the collision this case is about. The setting is 1960, at the height of the civil rights movement. Across the South, officials were fighting to suppress coverage of what was happening in their towns. And the movement's single greatest weapon was publicity, the national press, showing the rest of the country what segregation actually looked like. If you wanted to protect the old order, silencing that press was the way to do it. In March of 1960, a full-page advertisement appeared in the New York Times. It was titled, "Heed Their Rising Voices." It was a fundraising appeal. Money for the student protest movement, for the fight for voting rights, and for the legal defense of Dr. Martin Luther King Jr. And it described in vivid terms how peaceful protesters in Montgomery, Alabama had been met by the police. But the ad was not perfect. It contained a handful of minor factual mistakes. It got a detail wrong about which song the students had sung. It overstated some particulars of the police response. Nothing central, nothing malicious. The kind of small errors that slip into a passionate political appeal written in a hurry. But those small errors became the opening for an enormous lawsuit. Here is who stepped through that opening. A man named L.B. Sullivan was a city commissioner in Montgomery, and his responsibilities included supervising the police. Sullivan was not named anywhere in the advertisement, not once. But he argued that since the ad criticized the Montgomery police and he oversaw the police, the criticism was really about him. And on that theory, he sued for libel. And Alabama law made that suit devastatingly easy to win. The statements were treated as libel per se, meaning they were simply presumed to be false and damaging. Malice was presumed. Injury was presumed. Sullivan didn't have to prove he had actually been harmed or had lost a cent. The entire legal deck is stacked in the official's favor and against the newspaper. The result was staggering. An Alabama jury awarded Sullivan $500,000, an enormous sum in 1960, and he was not the only official to sue. Others filed their own claims over the same ad, each demanding another $500,000. Over a single advertisement, the New York Times suddenly faced the prospect of millions of dollars in liability. And that was exactly the design. Think about the message it sent to every newspaper in the country. If a few tiny errors in covering the civil rights movement could cost you your entire business, the safe thing, the only rational thing, was to stop covering it at all. Libel law was being quietly turned into a censorship machine, a way to make the national press fall silent about the South. When the case reached the Alabama Supreme Court, that court affirmed the verdict and stated its reasoning with striking bluntness. The First Amendment, it declared, does not protect libelous publications. In other words, the moment a statement is false, it loses all constitutional shelter, and the government is free to punish it however it likes. The New York Times took the case to the Supreme Court of the United States, and the question it raised reached far beyond one aide or one commissioner. Does the First Amendment protect speech that criticizes government officials, even when that speech contains some false statements of fact? Everything about the freedom to hold power accountable wrote on the answer. In 1964, the court delivered it. The decision was unanimous, 9-0. Justice William Brennan wrote the opinion, and the court reversed the Alabama judgment completely. But it was the way Brennan reversed it that reshaped American law for good. He began from a principle he stated in words now carved into the heart of the First Amendment. There is, he wrote, a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that such debate may well include vehement, caustic, and sometimes unpleasantly sharp attacks on the government and its officials. Criticism of power, in other words, is not a nuisance the Constitution tolerates. It is the very thing it protects. And then came the counterintuitive core of the ruling. In any genuinely free debate, Brennan reasoned, some factual errors are simply unavoidable. People challenging the government will sometimes get details wrong. If every honest mistake could trigger a ruinous lawsuit, critics would censor themselves into silence just to stay safe. So even false statements, he concluded, must receive some protection. Not because falsehood has value, but because punishing it too harshly would crush the truth along with it. His metaphor is the one lawyers still reach for. Free expression, Brennan wrote, needs breathing space to survive. A legal rule that forced every critic to guarantee the absolute truth of every single fact on pain of bankruptcy would suffocate exactly the debate the First Amendment exists to keep alive. Truth, to stay free, has to be allowed a margin to be imperfect. So the court built a new and deliberately demanding standard. A public official cannot win a libel suit over his official conduct unless he proves the statement was made with, in the phrase that has defined this area ever since, actual malice. And actual malice does not mean hatred or bad intent. It means the speaker either knew the statement was false or acted with reckless disregard of whether it was false or not. Consider how high that wall is. An honest mistake will not clear it. Even careless, negligent error will not clear it. The official must prove that the critic either flat out knew that he was publishing a lie or essentially did not care whether it was true, and he must prove it, the court said, with convincing clarity. That is why ever since, the overwhelming majority of libel suits brought by public officials collapse. Applied to Sullivan, the case fell apart. The court looked at the evidence and found no actual malice at all, only a few minor errors made in good faith. The $500,000 judgment was erased. Sullivan lost, and the entire Southern strategy of suing the civil rights press into bankruptcy collapsed along with his verdict. Some justices wanted to go even further. Justice Hugo Black, concurring, argued that the press should have an absolute, unconditional right to criticize officials, with no actual malice exception at all. Malice, he warned, was too slippery and elusive a concept, too easy for a hostile jury to find whenever it wished. It is a striking reminder that even on the winning side, the justices argued over how much protection was enough. What Sullivan established was a genuine revolution. Before it, libel was purely a matter of state law, and the Constitution had almost nothing to say about it. After it, the First Amendment set a nationwide floor. You cannot use a libel suit to punish criticism of public officials unless that criticism is a knowing or reckless lie. In the years that followed, the court extended the rule beyond officials to public figures generally. Celebrities, business leaders, anyone who steps into the public arena. And here is why it reaches all the way to you. That rule is the reason a journalist can investigate a senator, a comedian can savage a president, and an ordinary person can post a scorching review of a powerful company without being bankrupted over an honest slip. It is one of the quiet, load-bearing walls of American public life. It is also, quite literally, the rule that lets a channel like this one discuss public officials in public cases at all. It is also, right now, genuinely contested. Some critics, including 2 sitting Supreme Court justices, argue the actual malice standard has gone too far, letting the press damage reputations with too little accountability. Others warned that weakening it would hand the powerful the exact weapon Sullivan took away, the power to sue their critics into silence. It is a live and serious argument about the balance between reputation and freedom, and every side of it traces straight back to 1964. Step back and look at what this series has drawn. In Schenck, the government punished speech directly. In Barnett, it tried to force people to speak. In Tinker, it punished a silent, symbolic protest. And in Sullivan, it reached for a subtler weapon, punishing speech through the back door by bankrupting the people who dared to publish it. 4 cases, 1 freedom, tested from every angle. The right to speak, the right to stay silent, the right to protest without a word, and the right to criticize power without being ruined for it. So the next time you read a blistering story about a politician, or a brutal review of a powerful company, or watch someone criticize the government and wonder how on earth they get away with it, remember an advertisement, a few small errors, in an Alabama courtroom that tried to make the truth too expensive to tell. The Supreme Court decided that a free country has to leave its critics room to be human, even room to be wrong. Or before long, it will have no critics left at all. If that's the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching. And remember, this video is for education and history. It is not legal advice.